Welcome back to the deep dive. Um, we have a really fascinating stack of documents today that, well, it gets into the messy reality of human relationships in the law.
Yeah, it really does.
So we're looking at a case file from the Supreme Court of Wyoming. This is Stevens v. State, decided back in 1987.
Right. And this is one of those cases that sounds exactly like a hypothetical you'd get in a first-year law school classroom, but it actually happened to real people.
Yeah,
It forces us to look at a very specific high-stakes question, like at what point does being a loyal friend or maybe just a scared person trying to save their own skin, at what point does that turn you into a convicted felon?
right. It's that exact moment where loyalty clashes with the penal code.
Yeah.
So the core problem we're looking at today involves a man who lies to the police about a burglar. The big question for you, the listener, is this. Is he a criminal accessory for covering for the guy? Or is he just a liar acting in self-preservation?
And that distinction creates a massive difference in outcome. I mean, we are talking about the difference between being convicted of a felony for accessory after the fact, which carries serious prison time, versus simply being guilty of obstruction or perhaps committing no crime at all.
That seems like a terrifyingly thin line to walk.
It is.
And to navigate that line, we have to dissect the specific statute involved, which is Wyoming Statute Section 65202. So what's our path here?
So our analysis today is going to focus on two specific doctrines that come out of this case. First, we have rendering assistance, specifically, where the law draws the line between active concealment and passive denial.
Okay, active versus passive.
Exactly. And the second doctrine is specific intent. This is the requirement that the aid provided must be intended to help the principal offender, the bad guy, not just intended to help yourself.
Okay, let's unpack this. We need to start with the definitions, because rendering assistance sounds incredibly broad. Like, if I buy my friend lunch after he commits a crime, am I rendering assistance? Under the relevant statute, what exactly does that term mean?
It's defined quite specifically in Wyoming statute, section 65201. The general rule lists a few specific ways one can render assistance. Primarily, it means to A, harbor or conceal the person, B, warn the person of impending discovery, or D, use force, intimidation, or deception to obstruct anyone performing an act aiding in discovery or apprehension.
Okay, so harboring, warning, or using deception. Let's test that deception part first.
Yeah.
I feel like this is where most people get tripped up. If a cop asks me a question and I lie, that's deception, right?
You would think so.
So I want to bring in a case referenced in the source material to test this. It's State v. Clifford from Oregon in 1972. This story really sets the stage perfectly.
Yeah, Clifford is the perfect test case because the facts are just so extreme.
Right, so here is the situation. The defendant saw a man named Douglas Wright one day after Wright had murdered two people and kidnapped a 5-year-old boy.
Just horrific facts.
Yeah, this isn't just a shoplifter. This is a serious, dangerous fugitive. So the police grabbed the defendant on other charges and asked him point blank if he had seen Wright.
And this is the moment of truth.
Exactly. The defendant lied. He said he hadn't seen him or hadn't seen him in a long time. Now, intuitively, that feels criminal to me. You are lying to the police about the location of a murderer. So let's break that down. What is the core legal issue in Clifford?
The issue is whether a mere denial of knowledge, simply saying, I don't know or I haven't seen him, constitutes rendering assistance under the statute. Basically, does that specific type of lie count as the deception strictly prohibited by the law?
And what rule did the court apply there? Because if the answer is no, that feels like a loophole you could drive a truck through.
It certainly feels counterintuitive, but the rule is that while there isn't always a sharp line, examples of criminal conduct uniformly consist of an affirmative act. The court looked at the history of the offense and found that passive failure to disclose just isn't enough.
So simply not helping isn't the same as hurting the investigation. But he didn't just stay silent, right? He verbally lied.
That's true. But in the application, the Oregon court found that a mere denial of knowledge is effectively just passive non-disclosure vocalized. To be a crime, it must be an affirmative statement, like supplying a false alibi or a statement explicitly trying to shield the principal. Because the defendant in Clifford just denied seeing him, which is a negative statement, the conclusion was that his conduct did not amount to accessorial conduct.
Okay, I see the distinction. So if the police ask, did you see him? And I say, no, I'm just passively refusing to help. But if I say no because he was at the movies with me all night, now I have taken an affirmative step to create a fake reality.
Precisely. That is the critical distinction. One is a shield protecting yourself, or just refusing to engage, and the other is a sword, actively parrying the investigation away from the suspect.
That brings us to the second major way people get in trouble, harboring or concealing. Where is the line drawn here? Because we've all had friends crash on our couch. When does a sleepover become a felony?
This is a very common question. The general rule here distinguishes between active concealment and merely allowing a person to stay in one's home.
To illustrate this, let's look at United States v. Bissonnette, a 1978 case from the Eighth Circuit. This involves a grandmother, which usually makes people sympathetic, but the facts here are intense.
It creates a very clear contrast to the Stevens case we'll discuss in a minute.
So in Bissonnette, a grandmother kept her grandson and several other juveniles in her basement. This was right after a shooting and a jailbreak. She knew they were in trouble. Let's run the analysis on the grandmother. What was the issue?
The issue was whether the grandmother's actions constituted active concealment or if she was just letting family stay over. Was she providing housing or was she providing a hideout?
And the rule?
The rule is that conduct must go beyond merely offering the comforts of a home. It must show an affirmative, continuing pattern of conduct designed to prevent apprehension.
How did the court apply that to the grandmother in the basement? Because she could easily argue she was just keeping them fed and safe.
They looked at the specifics of her behavior. She told them to stay in the basement. She instructed them to keep the doors locked and the blinds drawn. She cooked for them specifically so they wouldn't have to go out. And she even berated them when they tried to contact friends because she was afraid it would lead to their discovery.
Wow. So she was running a tight ship.
Exactly. So the conclusion was that this was active concealment. It wasn't just housing, it was hiding. The specific steps she took, the blinds, the locks, the enforced secrecy, created a literal barrier against the outside world.
I want to make sure this really sticks for the listener because harboring is visual. Can you visualize the difference between a passive host and a criminal host based on these cases?
Absolutely. Think of the Bissonnette case as the basement bunker. Picture those fugitives huddled in the dark basement. The grandmother is frantic, pulling the blinds shut, locking the doors, cooking food in secret, and yelling at them to stay off the phone. The atmosphere is claustrophobic. It is an active effort to build a wall between the criminals and the police.
That's the criminal side. And the contrast.
Contrast that with a guy who just lets a friend sleep on the couch. Maybe they wake up, walk around town in broad daylight, go buy car parts. One is a fortress of secrets, the other is just a roommate situation. That visual is key to understanding why one is a crime and the other isn't.
That sets the stage perfectly. We have the mere denial rule for lying and the basement bunker rule for housing. Now, let's get to the main event.
This is where we see how those doctrines apply to a messy real-world situation.
Let's analyze Stevens v. State. First, what are the legally dispositive facts?
The setup starts on December 1st, 1985. Roy Dale Stevens, our appellant, agrees to let Harry Van Buren stay at his house. Crucially, Van Buren agrees to help Stevens find a truck part the next morning. At this specific moment, there is no criminal intent, just two guys planning to fix a truck.
Okay, so the sleepover's arranged, then the crime happens.
Right. Van Buren goes out and burglarizes Yellowstone Electric. At 8 p.m. that night, he comes back to Stevens' house and tells Stevens about it. Stevens explicitly says, "I don't want to hear about it."
So he just puts his head in the sand. What happens the next day?
Van Buren leaves early but returns around 7:30 a.m. They then go out publicly to look for the truck part. Stevens can't find the part, so he asks Van Buren for money to buy a car instead. Van Buren gives him $100, which logically came from the burglary the night before. They buy the car and drive home.
And that's when the police catch up to them.
Exactly. They get home, and the police are already there questioning Van Buren. Officers approach Stevens and ask about Van Buren's role. Stevens denies knowing anything about the burglary. He even tells them he learned his lesson from a past incident and wouldn't get involved. But about 15 minutes later, the police confront him with a statement from his girlfriend saying otherwise, and Stevens admits he knew about the burglary.
And what was the core legal issue?
Was there sufficient evidence to prove the elements of rendering assistance and intent required to sustain a conviction for accessory after the fact?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied Wyoming Statute, Section 65202A. The rule has two primary elements. First, the accused must render assistance to the person. Second, the accused must act with the intent to hinder, delay, or prevent the discovery or apprehension of the other person.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, rendering assistance?
The sub-issue here was whether Stevens's lie to the police or his housing of Van Buren constituted rendering assistance. The state argued Stevens helped Van Buren avoid discovery by denying knowledge. The court applied the Clifford standard, the mere denial rule. Stevens merely passively denied knowledge. He did not provide a false alibi or affirmative facts to shield Van Buren.
Right, he just played dumb.
Exactly. Now, regarding the housing, the state argued Stevens harbored Van Buren. The court applied the Bissonnette standard. Stevens made the agreement to house Van Buren before knowing of the burglary. He did not keep Van Buren concealed. They went out in public to look for truck parts and buy a car. There was no bunker. So the element conclusion was that the evidence was insufficient. Passive denial and public association do not equal rendering assistance.
Understood. Now, what about the second element, intent?
The sub-issue here was whether Stevens lied with the specific intent to aid Van Buren. The rule is that the intent must be to hinder the discovery or apprehension of the principal, Van Buren. The court looked at the context. Van Buren was already apprehended by police when Stevens lied. Plus, Stevens had a prior record, a felony with 2 to 4 years suspended and probation for a similar crime 4 years prior. He admitted he learned his lesson. He lied to protect himself from being implicated, especially regarding the $100 of stolen money used for the car, not to help Van Buren escape. So the element conclusion was that the evidence was insufficient. The intent was clearly self-motivated, not accessorial.
And after analyzing all the elements, what was the court's final conclusion?
The Supreme Court of Wyoming reversed the conviction and dismissed the charge. There was insufficient evidence for both the element of rendering assistance and the element of intent.
That is a complete dismantling of the prosecution's case. It sounds like Stevens walked away because he was a bad friend, not a good accomplice. Now, for the listener who might encounter this on an exam or in practice, how should they structure their thinking?
I would synthesize these rules into a diagnostic checklist, an exam framework.
Let's hear it.
First, check for affirmative conduct. When looking at rendering assistance, ask, is this a mere denial, a passive, I don't know, or is it an affirmative act like a false alibi? Mere denial is likely not a crime.
Okay, check for the lie versus the story. Point 2.
Second, check for active concealment. Regarding harboring, ask, are the blinds drawn and doors locked, like Bissonnette? Or is the suspect moving freely in public? Mere housing is not enough.
And third point.
Third, check the motivation, the intent. Ask, who is the defendant trying to save? If the lie is motivated purely by self-interest, like avoiding probation revocation, the specific intent to aid the offender is missing.
That is incredibly clear. It really highlights that in the eyes of the law, being a self-interested liar isn't always the same thing as being a criminal accessory.
Exactly. The law punishes the specific intent to aid a criminal, not just general dishonesty.
But here's where it gets really interesting to think about. We know Stevens got off because his lie was self-serving and passive. But here's a final provocative thought for you. If Stevens had provided a fake alibi, an affirmative act, while trying to save himself, would the self-interest defense still hold up? Or does the affirmative lie change the intent analysis entirely?
That is the million-dollar question. It pits the conduct element against the intent element in a way that would be a nightmare for a judge to untangle.
Something for you to chew on. Thanks for joining us on this deep dive into Stevens v. State.
Always a pleasure to analyze the law.
We'll see you on the next one.